Hello. Today I will read Nita Farahany's Incriminating Thoughts article, and I got to know this research, the new word um, called cognitive liberty through many news coverage recently. TikTok is letting people shut off its infamous algorithm, and then there were this Duke University law and ethics professor like heavily cited about her thoughts on cognitive liberty. Yeah, she has emphasized that prioritizing safety regarding like allowing you to have enough autonomy to determine your thoughts and directions, as opposed to be governed by all the social media platforms that are seeking your attention, and chasing whatever you go and whatever you see. So now we are losing our control, and so we need to reclaim the cognitive liberty as a legal right. And so she supported like TikTok's this types of move and other lawmakers approach. So I was curious about how cognitive liberty actually started, and what other like her research like relevant to this topic. And I searched briefly searched on Google Scholar, and I just searched like cognitive liberty, and it seems that there is not many like very established article yet, and like freedom of thought and freedom of conscience. um yeah, I feel like it's emerging and definitely worth being looked at. And then I came across her the same professor's 2012 article, and which was published in Stanford Law Review, and it's called Incriminating Thoughts. So I'm guessing that there are certain like laws that even punishing people for having some thoughts, instead of expressing those thoughts or implementing those thoughts by doing conduct. Yeah, so I will read this article. It's like 50 pages long, so relevantly shorter than other law review articles, but still long. So I will try to be really fast. Looking forward to getting to more about this content. Incriminating Thoughts, Nita A. Farahany. The neuroscience revolution poses profound challenges to current self-incrimination doctrine and exposes a deep conceptual confusion at the heart of the doctrine. Oh, self-incrimination doctrine means that you don't really need to confess your crimes, even if you did commit your crime. That's a very long-held constitutional criminal procedure doctrine. And in Schmerber versus California, the court held that under the self-incrimination clause of the Fifth Amendment, no person shall be compelled to prove a charge from his own mouth, but a person may be compelled to provide real or physical evidence. This testimonial physical dichotomy has failed to achieve its intended simplifying purpose. For nearly 50 years, scholars and practitioners have lamented its impracticability and its inconsistency with the underlying purpose of the privilege. This article seeks to reframe the debate. It demonstrates through modern applications from neuroscience the need to redefine the taxonomy of evidence subject to the privilege against self-incrimination. Evidence can arise from the identifying characteristics inherent to individuals. It can arise automatically without conscious processing. It can arise through memorized photographs, papers, and memories, or it can arise through responses uttered silently or aloud. This spectrum, identifying automatic, memorialized, and uttered, is more nuanced and more precise than the traditional testimonial physical dichotomy, and gives descriptive power to the rationale underpinning the privilege against self-incrimination. Neurological evidence, like more traditional evidence, may be located on this spectrum, and thus doctrinal riddles of self-incrimination, both modern and ancient, may be solved. identifying automatic memorialized utterances, recognizing cognitive liberty, discomforting thoughts, riddles revealed. The neuroscience revolution poses profound challenges to current self-incrimination. The court codified the basic dichotomous principle that the self-incrimination clause in the U.S. Constitution ensures that no person shall be forced to give self-incriminating testimony in a criminal case, but may be compelled to provide real or physical evidence. The Fifth Amendment protects against coercion to prove a charge against an accused out of his own mouth, but not extracting saliva from the same. Coercion to prove charge against an accused out of his own mouth, but not extracting saliva from the same. The dichotomy between testimonial and physical evidence has failed to achieve its simplifying purpose of making easier determinations of when Fifth Amendment privilege applies, and it opens the door to a future in which the government might easily target and obtain the hidden contents of the mind, from undisclosed thoughts to ideas and emotions. Scholars and practitioners lament the impracticability of a testimonial physical dichotomy, lambast its flawed historical roots, and introduce a myriad of new approaches for respecting its purpose. This article seeks to reframe the debate over what to be a witness means in the context of self-incrimination. It demonstrates both historically and through modern examples from neuroscience the inadequacy of defining to be a witness through a testimonial physical dichotomy. It proposes a new taxonomy of evidence that squares prior case law with the predominant descriptive rationale underlying the privilege. Yet in so doing, it foretells a comforting fate for a sphere of mental privacy. The following fictitious scenario provides a framework to understand how neuroscience reveals the need for a new taxonomy underlying the privilege against self-incrimination. A woman is murdered in her home, and the crime captured on a home security video recording. The recording reveals the woman struggling with an unidentifiable masked man holding a hammer with a uniquely patterned handle. In the ensuing struggle, the woman delivers a dizzying blow to the back of his head. A second masked man enters the room and says the first, "Let's go." The second man uses the hammer to fatally wound the woman. The video ends with the two men drag the woman out of the home. When the police arrives at the crime scene the next day, they find no trace of the crime save the videotape and the hammer. The police correctly suspect that the woman's husband is one of the perpetrators, and 2 weeks later bring him in for questioning. Now in the police interrogation room and faced with the husband, an uncooperative suspect who sits silently before them, the police contemplate methods by which they could obtain further evidence from him. At their disposal are the following techniques. Obtain structural images of the husband's brain to see if he suffers from head trauma in the region where the perpetrator suffered a blow to the head. Measure his automatic emotional and psychological responses to stimuli, such as a photograph of his wife. Obtain his spoken, written, or stored memory of the night of the crime, or elicit brain-based on but interpretable responses to their questions by whatever means necessary, including torturous ones. Each technique the police could use would yield tangible physical evidence detectable through modern neuroscientific methods. The police could use such evidence to make inferences about the husband's involvement in the crime. Faithful application of the testimonial physical dichotomy should therefore predict that the police could compel any of the brain-based evidence without running afoul of Fifth Amendment. And yet, something seems amiss with this prediction. It fails to capture intuitions about mental privacy and autonomy of self. Other scholars have already recognized the potential conflict between emerging neuroscience and current self-incrimination doctrine. That scholarship has been limited by its narrow focus on particular neuroimaging technologies and by an understandable attempt to fit new neuroscience onto old categories. Even the more nuanced discussions have included only stimuli based imaging without considering the myriad of the other applicable neuroscientific technologies at issue. This narrow approach makes suspect the predictions these scholars make for how certain neuroimaging technologies would fare under current doctrine. Using outmoded and historically rejected rationales such as mental privacy, these scholars divide on whether neuroimaging is physical and unprivileged or testimonial and privileged. In addition to disclosing the contents of suspect's mind, brain fingerprinting has the ability to record the presence of a link between facts and to determine whether the person had any role in the crime. A person possessing actual knowledge of the criminal event being examined, however, would subconsciously connect the fact to the criminal event, and the resulting electrochemical brain wave would be recorded by the neuroimaging technique employed by brain fingerprinting. This article instead takes a more integrated view of cognitive neuroscience to bring coherence and restore meaning to self-incrimination doctrine. An integrated approach reveals that evidence can arise from identifying characteristics concerning individuals. It can arise automatically without conscious processing. It can arise through memorialized photographs, paper, or memories, or it can arise as uttered responses, whether made silently or aloud. A spectrum of evidence that spans identifying, automatic, memorialized, and uttered evidence offers more nuance and precision than the traditional testimonial physical dichotomy and gives descriptive power to the rationale underpinning the privilege. That rationale, the excuse model of the privilege, provides a constitutional excuse for a suspect's silence when failing to do so would put the defendant in the difficult position of choosing between lying, facing contempt, or incriminating himself. But the spectrum also does more. The excuse-based model, now imbued with greater descriptive force, reveals that current doctrine is misaligned with moral intuitions about mental privacy. The limited excuse for silence has been described as balancing societal interest in securing truth in criminal prosecutions, in promoting law-abiding behavior, and in preserving the legitimacy of the criminal justice system. Although descriptively robust, that limited excuse may simply be too weak to protect individuals against self-incrimination in the post-neuroscientific era. This article begins with the doctrinal underpinnings of the testimonial physical divide, including Schumacher versus California and its progeny. Because this landscape is already well groomed, the discussion here focuses on the nuances of the dichotomy and how it aligns with an excuse-based rationale of privilege. Part 2 then uses modern examples from neuroscience to reveal that impracticability of the testimonial physical dichotomy and its applicability to emerging technology. Neuroscience offers more than a mere axe to cleave the divide. It provides an analogical tool by which a new taxonomy of evidence can be constructed along that spectrum of evidence. Past cases and future ones are located, which both explains current doctrine and predicts its evolution. The spectrum runs from identifying to automatic, memorialized, and finally uttered evidence. Realigning self-incrimination privilege along this new spectrum instead of the testimonial physical dichotomy brings coherence to existing doctrine and enables a more meaningful prediction of how emerging neuroscience will fare. That prediction that identifying automatic and even voluntarily memorialized evidence go beyond the scope of privilege motivates a timely discussion in Part 3 about how an excuse-based model of privilege fails to reflect modern intuitions about the purpose of the self-incrimination clause. Part 3 concludes by finding that although other constitutional guarantees may provide some protection for cognitive liberty, it is unlikely that our existing constitutional structure will ensure a sphere of mental privacy that will safeguard individual autonomy. Part 1. The development of the testimonial physical dichotomy. A early conflict over the scope of privilege. Well before Schmerber versus California, or the incorporation of the self-incrimination clause of the Fifth Amendment against the states, courts disagreed about when a criminally accused person could be compelled to be a witness against himself. Some state courts believed the privilege guarded against the compulsion of any form of self-incriminating evidence, while others found it applicable only to testimonial statements. States that interpreted the privilege broadly held that an accused could not be forced to exhibit his physical features to a jury, to try on articles of clothing before the jury, to submit to a physical medical examination, or to match a footprint impression found at the crime scene. By contrast, state courts that interpreted the privilege more narrowly found it permissible to compel an accused to grow a beard, to try on articles of clothing before the jury, to provide handwriting exemplars, to submit to physical examination, to provide fingerprints or other exemplars, or to illustrate the fit of his foot to a crime scene footprint. The disagreement was fundamental to the purpose and the scope of the privilege against self-incrimination. The broad approach favored a liberal construction guarding against governmental invasion of personal rights, and consequently interpreted the privilege as a prohibition against compelling from a criminal accused any evidence that in any manner would tend to self-incriminate. Even cases adopting the broad approach show internal disagreement, whereupon careful reading one sees these courts parsing related precedents to distinguish between compelled physical evidence furnished in open court from out-of-court compulsions. The narrow approach, by contrast, found a common purpose among the various constitutional texts to protect the accused against inquisitions that extracted guilt either from a suspect's own lips or by her own communication, written or oral, which revealed her conscious mind. Because physical evidence, particularly when used for purely identifying purposes, did not run afoul of this purpose, the privilege did not extend to such compulsions. A codified divide. In the post-incorporation case of Schmerber versus California, the Supreme Court resolved anew whether involuntarily taking physical evidence from on, when was it? 28? Accused compels him to be, let me see when it was decided. 1966. Compels him to be a witness against himself, contrary to the Fifth Amendment privilege against self-incrimination. While Schmerber did not create the testimonial physical dichotomy, it did codify the rule and establish its parameters. Schmerber challenged the involuntary taking of his blood sample after he was arrested and taken to the hospital for drunk driving. Justice Brennan wrote the opinion for the court, which rejected the Fifth Amendment claim that the forcible taking of a blood sample from the accused had compelled him to be a witness against himself. The self-incrimination clause, observed the court, protects an accused only from being compelled to testify against himself or otherwise provide the state with evidence of a testimonial or communicative nature. Despite the evident conflict between the states on this issue, the court opined that its own prior history had made clear that seizure of non-communicative items like blood, fingerprints, or a suspect's resemblance, for example, facial identification from a lineup, does not implicate the privilege. Many argue that to arrive at this result, the Schmerber court departed from the origins and doctrinal development of the self-incrimination clause. Some scholars have persuasively argued that a more historically rooted analysis of the privilege directly refutes the divide the court created. What the court did rely upon illuminates the operating rationale behind the privilege at the time. Justice Brennan cited Holt versus United States as the leading case in his formulation of the testimonial physical dichotomy. Holt addressed the admissibility of evidence when the accused, prior to trial and over his protest, put on a blouse that fitted him. Holt argued that compelling him to submit to the modeling of the blouse violated his privilege against self-incrimination. Justice Holmes, writing for the court with little explanation or analysis, rejected that argument as based upon an extravagant extension of the Fifth Amendment, and found instead the prohibition of compelling a man in a criminal court to be witness against himself is prohibition of the use of physical or moral compulsion to extort communications from him, not on exclusion of his body as evidence when it may be material. The objection in principle would not forbid a jury to look at a prisoner and compare his features with a photograph in proof. In other words, the privilege did not extend so far as to stymie or reasonable and ordinary investigative techniques available. Both Holt and other cases upon which the court relied make clear that the privilege is not absolute and will be interpreted in a manner that allows reasonable criminal investigations to proceed. Some argue that instead of a balancing approach, the Schmerber court adopted the approach to the privilege that John Henry Wigmore articulated in his treatise on evidence law. Wigmore advanced the perspective that the privilege is limited to testimonial disclosures. It was directed at the employment of legal process to extract from the person's own lips an admission of guilt, which would thus take the place of other evidence. While Brennan did cite favorably to Wigmore in a footnote, he nevertheless emphasized that the court's approach was not meant to adopt Wigmore's formulation. Brennan instead blended Wigmore and Miranda versus Arizona to find that the privilege strikes a balance between the individual interest in being free from coercive measures of the balance of the state and the societal interest in evidence sought. Rather than a bright-line rule, Justice Brennan was instead introducing a balancing test, using the form of evidence as a guide to courts in assessing its admissibility under the rule. The resulting framework from Schmerber is that the privilege against self-incrimination creates a bar against compelling communications or testimony from an accused, but not against making the accused a source of real evidence when his testimonial capacity are not also implicated. Because Schmerber served only as a donor, his blood sample was unprivileged. The important caveat to the physical evidence rule that one cannot be compelled to be a donor if doing so implicates his testimonial capacities has resulted in a considerable confusion about when evidence falls within or outside the scope of privilege. The spectrum I propose restores meanings to this nuanced exception. Rationalizing privilege. The testimonial physical dichotomy purportedly aligns with the rationale that the privilege against self-recrimination serves. Locating a simple and coherent rationale has proven an elusive task for courts and scholars over time. The three most popular rationales, protecting individual privacy, protecting individual autonomy, and avoiding placing the defendant in a cruel trilemma of choice, each suffer substantial descriptive shortcomings. The excuse-based model of privilege, understood as a limited right to remain silent balanced against societal interest in law-abiding behavior, provides the best descriptive account of settled Fifth Amendment law. This rationale, introduced by William Stuntz over 20 years ago, nevertheless lacks normative appeal as emerging technology takes hold. By contrast, self-incrimination as protection against physical or mental privacy has significant normative appeal but is descriptively unsupportable. Proponents of the privacy-based rationale argue that privilege does and should protect human dignity. Compelled self-incrimination, they argue, would interfere with the ability of the accused to assess the moral implications of her actions, would thereby inhibit, stultify, interrupt the process by which the accused decides what to do about whatever criminal responsibility rests at his doorstep. Matters such as the admission of wrongdoing, the self-condemnation, the revelation of remorse are a matter between a man and his conscience and lies at the heart of the Fifth Amendment. In Fisher versus United States, the Supreme Court expressly rejected a privacy-based rationale for the privilege. The court held that compelled production of accountants' documents in possession of a suspect's attorney did not violate the Fifth Amendment. In so doing, it concludes that the court has never on any ground, personal privacy included, applied the Fifth Amendment to prevent the otherwise proper acquisition or use of evidence which, in court's view, did not involve compelled testimonial in self-incrimination of some sort. Rather than finding a broad individual interest in keeping certain things private, the court directed its Fifth Amendment inquiry at the nature of the evidence compelled. Real evidence, such as papers in the hands of a third party, is beyond the scope of privilege even if that evidence contains private information. Instead, irrespective of whether the evidence takes the form of one's physical body or one's physical papers, the privilege does not bar the compulsion of otherwise private information from being revealed. Moreover, a state may compel testimony once immunity has been granted, even for the most preciously guarded private secret. If the privilege in fact protected privacy, or even only mental privacy, the relevant inquiry should focus on the substantive content of the compelled disclosure. Instead, settled Fifth Amendment law focuses on the criminal consequences of disclosure. The immunity doctrine further underscores this point. If privacy were at the heart of the privilege, one would expect that immunity from prosecution could not override it. Unexcused theorists, by contrast, would expect that granting immunity would indeed render the privilege inapplicable, since immunity puts no pressure upon the defendant to lie when questioned. Privilege as excuse ensures that defendants have only one legal and rational choice to testify truthfully. The attractive and yet elusive theory that the privilege protects individual autonomy similarly lacks descriptive grounding. Whether autonomy refers to the dignity against bodily intrusions or against being forced to condemn oneself, neither squares with self-incrimination doctrine. Compelled production of bodily evidence and forced public self-condemnation are both permissible under settled Fifth Amendment law. Defendants can be compelled to be donors of real evidence when applicable and compelled to testify when immunized, thereby assisting in their own public and government condemnation. Balancing governmental and individual interest provides one descriptively appealing alternative to the absolute privacy rationale. In both Schmerber and other cases, the court has characterized the privilege as a balance between an individual interest against self-incrimination and societal interest in the evidence that the suspect holds. Yet, standing alone, this rationale fails to explain much of the doctrine. A balancing test traditionally yields individual interest to societal ones when the governmental interest is the most essential, but the privilege against self-incrimination works in nearly the opposite way. It allows compelled testimony only when immunity has been granted, thereby withholding from society the benefit of using that evidence to prosecute the testifying witness, and a generic balancing test fails to explain much by virtue of its generality. For the balancing test to be robust, the factors to be considered and the way to accord with each must be identified ex ante. Otherwise, the bold claim that the privilege seeks to balance governmental and individual interest explains all cases equally well and all cases equally poorly through ad hoc backward rationalization. The rationale that enjoys the most widespread support is that the privilege seeks to protect the criminal defendant from cruel trilemma of self-accusation, perjury, or contempt. While this rationale has faced forceful attack, it has both historical and normative force such that courts and scholars frequently cite it as the purpose underlying the privilege. Historically, the privilege was set to protect against the use of legal compulsion to extract from the accused the sworn communication of facts which would incriminate him. This was the procedure employed in the Star Chamber, in which a suspect was put under oath and compelled to testify, often for crimes yet unknown and uncharged. Informed by this history, Both scholars and court describe the privilege as a way to guard against official abuse such as torture and other third-degree tactics used by investigators. In Miranda versus Arizona, the court discussed numerous severe police abuses involving beatings, hangings, whippings, and sustained questioning in order to extort confessions. Such flagrant violation of the law by police tended to produce false confessions and make the police and prosecutors less zealous in searching for objective evidence. The Miranda Court sought to limit these practices through its interpretation of Fifth Amendment privilege. Both the history of its adoption and subsequent developments in the doctrine suggest the privilege at least exists to protect individuals against brutal, violent police tactics, if not the more modern psychological ones as well. Major descriptive problems nevertheless keeps the cruel trilemma from fully succeeding. The law often forces witnesses to make choices at least as cruel as the privilege purportedly protects against. Why would it be any different under the Fifth Amendment? Additionally, while an innocent suspect may feel pressure to prove his innocence or to seem cooperative to investigators, the innocent suspect does not risk self-incrimination or perjury by telling the truth. Yet the privilege protects both the guilty and innocent alike from being compelled to give testimonial self-incriminating evidence. So while it seems certain that at least some element of balancing autonomy and restraining investigator factors into Fifth Amendment analysis, something more must be said to make sense of underlying rationale. The excuse-based model. William Stuntz provides a useful way to positively reconcile the two most popular but seemingly divergent rationales, societal balancing and the cruel trilemma. This theory analogizes the privilege against self-incrimination to criminal excuse. Criminal excuse concerns hard but not cruel choices that many of us might make wrongly. In previous work, I described criminal excuse more fully as societal recognition of human frailty, choosing to hold individuals less responsible for wrongdoing when the average person would likely succumb to the same temptation to which the defendant did. By allowing criminal excuse in some situations, the criminal justice system recognizes that society ought not hold a criminal defendant to a higher standard of conduct under the circumstances than could be expected of the average member of society. The average person often chooses poorly when his judgment is clouded by extremely external pressure. And yet, Stunt aptly points out criminal excuses are not absolute and become unavailable when the societal cost of recognizing an excuse are high enough to warrant holding the individual fully responsible for his crime. Stunt's excuse model converges with the cruel trilemma rationale by focusing on the temptation a defendant faces to falsify his responses to avoid self-incrimination. Similar to criminal excuse, the history and development of self-incrimination doctrine reveals an inclination to give criminal defendants immunity for their silence rather than an excuse of perjury. Immunized silence applies only when an accused faces a choice that would tempt the average member of society to commit perjury, whether because of the force used to extract an admission or the threatened criminal penalty, to instead force the suspect to cooperate and then penalize his perjury would hold the suspect to a higher standard of conduct than those judging him could meet. Like any criminal excuse, the privilege is not absolute. It is balanced against societal interest in encouraging law-abiding behavior and the pursuit of truth in criminal justice. Unlike finding that any cruel choice is an impermissible one, an excuse-based privilege makes piercing silence permissible when the social cost of recognizing a right against self-incrimination would be too expensive in terms of criminal deterrence. As a balancing test, excused silence is merited only when a suspect is compelled to communicate a potential falsehood. This idea of choice is easiest to understand by considering a suspect on the witness stand. If he is asked about his involvement in the crime while he is on the stand, he faces a difficult and pressurized moment of truth during which he must decide whether to communicate falsehood, remain silent, or self incriminate. The temptation to commit perjury, the consequent risk of falsehood, and the availability of other means by which the government can seek evidence all predict that under such circumstances the defendant would be immunized from testifying. As a rationale, the model has great descriptive force, but only when used in conjunction with the spectrum of evidence proposed in this article. By contrast to the approach in this article, Stuntz demurs to the testimonial physical dichotomy, arguing merely that general thrust of the distinction between physical and testimonial evidence makes sense from an excuse perspective, while the same cannot be said of privacy or autonomy theories. But he gives no more than one paragraph of discussion to this dichotomy in the paper and fails to appreciate how blurred those categories have become. His excuse-based rationale regains its descriptive force and applicability through the spectrum proposed in this article, a power otherwise lost and until now never before applied to the gray area between testimonial and physical evidence. Together with the spectrum proposed herein, the excuse-based model provides the best positive account of how self-incrimination cases are decided. By grounding the privilege in a theory that incorporates society's moral preference for truth and law-abiding behavior, the theory seems also to have normative force. As a limited right to remain silent, the theory gives legitimacy to perjury as a criminal offense. By giving the defendant the option to remain silent rather than to state falsehoods, when the defendant chooses to create a falsehood, he is appropriately condemned. Excuse as privilege maximizes the reliability of the testimony obtained. The temptation to commit perjury when faced with the difficult choice of self-incrimination does and should make us doubt the reliability of compelled testimony. We reasonably suspect that physical and psychological force yields false confessions rather than reliable truth upon which the state can rely for legitimate criminal prosecutions. Despite the existing model's accolades, Part 2 revealed through emerging neuroscience that the existing model will likely fail to protect some individual liberties that society may value. As discussed in Part 3, the coming siege against cognitive liberties may require new ways to protect incriminating and even innocent thoughts. Okay, I guess this article introduces three different avenues of justifying the self-incrimination doctrine. First was privacy, second was autonomy, third was avoiding the trilemma. And she said both privacy and autonomy has normative appeal, but does not have descriptive force because it was never acknowledged by courts so far. And because privacy and autonomy are somewhat absolute or objective, I would say, if it is in the realm of privacy, it has to be protected. But self-incrimination testimony, because this person is already suspected to commit a crime, and in many cases, some people might commit a crime in this scene, and so there is another interest to figure out what was truth, and because there was a victim and there is the government and legal enforcement has the interest to find the facts, and in that case, privacy and autonomy are structurally diminished. So this professor thinks that the excuse theory makes the most sense in this scenario, because the excuse theory is comparing the suspect and against the general or average level of average human. And so if average human was facing the external like pressure, and they want to make up story, or they want to maybe lie to mask some ugly truth. And so even if they didn't commit a crime, because there is a consequence, like intimidating consequence, and they want to look like a better person and avoid any risks on their path. So there is a quite likely chance that people can make up their story. So if average person can do that, like punishing potential criminal or suspect for that reason is not fair. Yeah, so that's and yeah, so that's the reasoning. So that's why self-incrimination doctrine has allowed some physical evidence admission, or forcing people to wear some clause, or giving the document that include some proof against themselves, have been allowed under this doctrine, because in that case they would not be mentally like pushed to lie because they are objective. I don't know. Yeah, so I might need read more to fully understand this excuse theory, which is a little bit confusing to me. But she endorses the excuse theory here, and then I think she might link between the excuse theory, grounding excuse theory with the evidence in found in neuroscience in part 2, and may expand the normative foundation for Fifth Amendment to the cognitive liberty. So that's my guess. So today it's already midnight here in Pacific West, and so I would go to sleep. And so today's video is a little bit shorter, and I will go over part 2 and 3 tomorrow. See you. Thank you.